Okay, the Rules Committee will come to order. Today, we are meeting on a contempt report recommended last week by the House Select Committee to investigate the January 6th attack on the U.S. Capitol. The report says that former Trump administration officials Peter Navarro and Daniel Scavino are in contempt of Congress for their failure to comply with duly issued subpoenas, and it refers the matter to the United States Attorney for the District of Columbia. This action is necessary because both Mr. Navarro and Mr. Scavino have information which is materially relevant to the Select Committee's investigation. Yet both have failed to produce documents and appear for depositions despite repeated attempts by the Select Committee to compel them to do so. And before some of my Republican colleagues start talking about executive privilege, let me remind them that the Biden administration has not invoked executive privilege, and Donald Trump himself has not engaged with the Select Committee to invoke executive privilege here. In fact, when he did try to block the release of other documents to the Select Committee, a federal court concluded that his claims of executive privilege would have failed even if he were still president. And then the Supreme Court refused to hear his appeal, citing that decision. In fact, just last week, another federal judge ruled that one of Donald Trump's lawyers, John Eastman, had to turn over documents to the Select Committee and concluded that the former president, more likely than not, committed crimes in attempting to obstruct the counting of electoral votes. And former Trump administration official Steve Bannon has been indicted and is now facing trial for his failure to comply with the committee's subpoenas. Yet, rather than follow the law, Mr. Navarro and Mr. Scavino have chosen to obstruct the work of Congress and try to prevent us from getting to the truth about how the January 6th attack was planned. Notwithstanding their attempts to hide from the American people, the facts uncovered by the Select Committee are alarming. The committee has revealed that the chaos and violence of January 6th was not spontaneous. It was not a normal tourist visit or a rally that got out of hand. It was a sophisticated, coordinated attack, planned and executed at the highest levels of government and designed to nullify the outcome of a free and fair election. There were PowerPoints created about how to stop the certification of the votes. Memos circulated deep within the West Wing about declaring a national emergency and using the military to seize ballots. Campaigns to pressure people like former Vice President Mike Pence to just throw away electoral votes from the states President Biden won. And this was not some fly-by-night operation. It was a months-long scheme to lie to the American people, culminating in a violent attack to prevent Congress from certifying the will of the voters. An operation that, by their own admission, directly involved both Mr. Navarro and Mr. Scavino. In December of 2020, Mr. Navarro released a report repeating disproven conspiracy theories about the 2020 election. The Select Committee has uncovered that his report was circulated within the West Wing by officials who were pushing the lie that President Trump had won even though he had lost. Navarro's report was even included in the tweet where President Trump announced his January 6th Stop the Steal rally. And Mr. Navarro reportedly worked with members of the Trump campaign's legal team to directly encourage state legislators to overturn the results of the 2020 election. Just 4 days before the attack on the Capitol, Mr. Navarro joined a call with Donald Trump, encouraging the lawmakers to overturn the will of the voters and appoint President Trump, even though he lost the Electoral College in 2020 by the same margin he won in 2016. Of course, losing the popular vote both times by a fairly large margin. For his part, Mr. Scavino spoke with former President Trump multiple times by phone during the attack, and he was present with him during the period when Americans inside the Capitol building and across the nation were urgently calling on him for help to halt the violence while he watched it all on TV. Refusing to take action as members of Congress, Fox News hosts, even members of his own family begged him to intervene. It's a 7.5-hour long period that we learned last week is mysteriously missing from White House call logs. 7.5 hours. I mean, only 18 and a half minutes of Nixon's call logs were missing during the Watergate. And here we have 7.5 hours unaccounted for. Mr. Scavino's recollection of those hours is extremely important in determining whether President Trump sought, through his own action or inaction, to corruptly obstruct or impede our work in Congress as we met to count electoral votes. The Select Committee also has reason to believe that Mr. Scavino had advance warning of the possibility of violence on January 6th because Mr. Scavino had a history of monitoring websites where users openly discuss acts of violence in the days leading up to the attack. Mr. Scavino and Mr. Navarro have both bragged publicly about their efforts to overturn the election, yet neither had the courage to appear before the Select Committee. Well, I believe there must be accountability for what happened, or it will happen again. Nobody is above the law. Contempt of Congress is a serious federal crime punishable by up to a year in prison and fines up to $100,000. This is not a step that we take lightly, but it is sadly a step that Mr. Navarro and Mr. Scavino have forced us to take in pursuit of the truth about the dastardly attack on American democracy that took place on January 6, 2021. And with that, let me turn to our ranking member for any comments he wishes to make.
Thank you very much, Mr. Chairman. Our hearing today covers another resolution from the majority's partisan investigation into the events of January 6th, holding two more individuals in contempt of Congress. Unfortunately, the majority Select Committee investigation has been tainted from the beginning by political considerations. Speaker Pelosi ensured that was the case the moment she chose unilaterally to refuse to seat Leader McCarthy's choices of Republican members to sit on the Select Committee. Today, we're once again seeing the results of that inherently political investigation. Rather than allowing Republicans an honest opportunity to work through these issues in a bipartisan way, Speaker Pelosi instead determined that she needed to do everything in her power to ensure that she got the political result she wanted, even when her actions went against the longstanding traditions and norms of the House. The two individuals who are the subject of today's criminal contempt referral were both high-ranking officials in the Trump White House. As the committee is well aware, President Trump has repeatedly asserted questions of executive privilege. My understanding is that both of these individuals have complied with President Trump's request and have themselves asserted executive privilege in response to the Select Committee's wide-ranging subpoenas, as they should have. Indeed, both of these individuals have a legal duty to do so. Nonetheless, the Select Committee is now seeking to refer these two individuals for prosecution for criminal contempt. I would remind the committee that criminal contempt is inherently punitive. It does not force the production of documents or compel absent testimony. Rather, it merely seeks to publicly punish and shame an individual for noncompliance. The two individuals at issue have presented legitimate concerns about the scope of subpoenas issued to them and have raised legitimate concerns surrounding executive privilege. These concerns are for the courts to decide, not the House. The more the Select Committee seeks to abuse its subpoena authority, the more the House authority will be weakened in the long run. We would be better served to protect the House's subpoena power by doling them out judiciously in a fair and constitutional way. And we would be much better served not to make punitive criminal contempt referrals for individuals who are adhering to the former president's wishes concerning executive privilege, at least until the courts have made a final decision with respect to the scope of executive privilege. Unfortunately, I fear the majority will continue to erode the legal standing and credibility of the institution with the partisan manner in which they use the subpoena authority of the House. With that, Mr. Chair, I yield back.
Hey, Ranking Member Cole yields back. I thank him for his opening. I'd like to welcome our witnesses to provide testimony on a resolution recommending that the House of Representatives find Peter K. Navarro and Daniel Scavino, Jr. in contempt of Congress for refusal to comply with subpoenas duly issued by the Select Committee to investigate the January 6th attack on the United States Capitol. Chairman Thompson and Vice Chair Cheney, we are delighted that you are here. I now recognize the gentleman from Mississippi, Chairman Thompson.
Thank you, Mr. Chairman and Ranking Member Cole. It's regrettable whenever the Select Committee needs to take the time of the Rules Committee. It's regrettable because it's a result of someone blatantly ignoring the rule of law and undermining the investigative and oversight authority of this body. Today, we are talking about Dan Scavino, Peter Navarro, two former White House officials. In this case, it's also regrettable because the situation is so clear-cut that the House should adopt a contempt resolution by unanimous consent. This distinguished committee shouldn't have to spend an afternoon debating it. The actions of these men are so blatant and brazen that no member of this body should doubt that they are in contempt of Congress. Dan Scavino and Peter Navarro were two of the ex-president's senior advisors on January 6th, and in the run-up to that date, Mr. Scavino was Mr. Trump's top communications aide. Taxpayers paid him to hold the keys to the infamous Twitter account. Mr. Navarro was a trade advisor, but whose activities severed far outside that lane. Both of these men have refused to comply with the Select Committee's subpoena in any way, based on assertions of executive privilege. First of all, the Select Committee wanted to ask both of them questions dealing with matters that clearly fall outside any possible claim of executive privilege. To put it plainly, they were both involved in efforts to challenge or overturn the election. Last I checked, a president's attempt to stay in power after the people voted him out of office aren't the sort of things where executive privilege applies. Secondly, and here's where it gets a little more complicated, neither of these witnesses has properly asserted a claim of privilege. That's lawyer talk, so let me put it more plainly. If you're a witness in some sort of legal proceedings, it may be a criminal investigation, it may be a civil lawsuit, it may be a congressional probe. You may get a subpoena, an order telling you to show up at such a place and such a time to answer questions. You have to show up. That's the law. Now, when you show up, there are a few reasons why you may not have to answer questions. Witnesses have the prerogative to raise constitutional rights in response to congressional inquiries. For example, we all know the phrase, pleading the fifth. That means someone refuses to answer a question because the answer may subject them to criminal prosecution. The Constitution protects us from answering questions like that. And then there's executive privilege, which makes sure a president's sensitive conversations about official government business stay confidential unless outweighed by congressional investigative needs. These are important privileges. Witnesses have the right to assert them, and the Select Committee respects that. We follow the rules of the House. The rules lay out procedures for considering lawful assertions of these privileges. But here's the thing. If you want the protection of any of these privileges, you have to show up and explain why. We have had plenty of witnesses who fall into that category. We've had witnesses who've shown up and to every question claim their constitutional Fifth Amendment rights, asserting that their answers might subject them to criminal prosecution. The Select Committee respects those claims. At this point, none of the witnesses who have done that are facing any criminal contempt citation by the House. I think we'll hear a lot of attempts to muddy the waters about privileged claims, especially when it comes to Mr. Scavino. That's his lawyer tried to negotiate with the committee, that he wanted to find a way to come in, but he had such grave concerns and reverence for the institution of the presidency. At this point in our investigation, there's a mounting body of legal rulings rejecting the ex-president's claim of executive privilege. That makes Mr. Scavino's claim thin to begin with. Mr. Navarro are even thinner, as he has produced no evidence that the former president has even attempted to invoke executive privilege about anything related to his former trade advisor, either directly or indirectly. And the current president has stated clearly that he is not asserting the privilege for either witness with respect to subjects under investigation by the Select Committee. Unfortunately, Mr. Scavino and Mr. Navarro persist and clinging to a flimsy shield. Fine, if you want to make those claims, come in, take an oath, take a seat, and make those claims on the record on a question-by-question basis. But since they won't explain it to us, they'll need to be accountable to a federal judge instead. Mr. Scavino and Mr. Navarro have a legal obligation to comply with the congressional subpoenas issued by the Select Committee. Instead, they're acting like they believe they are above the law. If we fail to cite them for contempt, we weaken this institution, not just today, but a month from now, a year from now, and going forward. All members should keep that in mind as you consider this resolution. I ask respectfully that you bring this measure to the floor swiftly for the House's consideration. I thank you and yield back.
Thank you very much, Vice Chair Cheney.
Thank you very much, Chairman McGovern. Thank you, Chairman Thompson, Ranking Member Cole. Thank you very much. As you all know, we are entering a critical stage of this investigation. We have learned that President Trump and his team were warned in advance and repeatedly that the efforts they undertook to overturn the 2020 election would violate the law and our Constitution. They were warned that January 6th could and likely would turn violent. And they were told repeatedly by our state and federal courts, by our Justice Department, and by the agencies of our intelligence community that the allegations of widespread fraud sufficient to overturn the election were false and unsupported by the evidence. And yet, despite all of these specific warnings, President Trump and his team moved willfully to attempt to halt the peaceful transfer of power, to halt the constitutional process for counting votes. Today, Mr. Chairman, we address two specific witnesses who have refused to appear for testimony. Mr. Scavino worked directly with President Trump to spread President Trump's false message that the election was stolen and to recruit Americans to come to Washington with the false premise that January 6th would be an opportunity to, quote, take back their country. This effort to deceive was widely effective and widely destructive. The committee has many questions for Mr. Scavino about his political social media work for President Trump, including his interactions with an online forum called The Donald and with QAnon, a bizarre and dangerous cult. President Trump, working with Mr. Scavino, successfully spread distrust for our courts, which had repeatedly found no basis to overturn the election. And Trump's stolen election campaign succeeded in provoking the violence on January 6th. On this point, there is no doubt. The committee has videos, interviews, and sworn statements from violent rioters demonstrating these facts. Mr. Navarro will also be a key witness. He has written a book boasting about his role in planning and coordinating the activity of January 6th. And yet, as the chairman noted, he does not have the courage to testify here. We have many questions for Mr. Navarro, including about his communications with Roger Stone and Steve Bannon regarding the planning for January 6th. As a federal judge concluded last week, quote, based on the evidence, the court finds it more likely than not that President Trump corruptly attempted to obstruct the joint session of Congress on January 6, 2021. Our committee will continue to litigate to obtain the testimony we need. We have already defeated President Trump's efforts to hide certain White House records behind a shield of executive privilege. As the court in that ruling said, quote, under any of the tests advocated by former President Trump, the profound interest in disclosure advanced by President Biden and the January 6th committee far exceed his generalized concerns for executive branch confidentiality. That same conclusion should apply to Mr. Scavino and Mr. Navarro. In a time when my Republican colleagues, many of them, are seeking to minimize the events of January 6th and putting politics above their oath of office, there are many other Republicans our committee has heard from. Many Republicans in state houses state agencies, at the Department of Justice, and staff in President Trump's own White House, who continue to demonstrate a firm and unwavering commitment to their constitutional obligations. These men and women are models for the American people. They are the kind of public servants our nation needs. Men and women who know our institutions don't defend themselves and who recognize the obligation that comes from holding positions of public trust. We live in the greatest constitutional republic in history. No citizen in our republic can be a bystander. If we do not stand for our freedom and for our Constitution, we will lose them. In his ruling last week, Judge Carter put it this way: if President Trump's plan had worked, it would have permanently ended the peaceful transition of power, undermining American democracy and the Constitution. If our country does not commit to investigating and pursuing accountability for those responsible, the court fears January 6th will repeat itself. Close quote. I urge my colleagues to support this resolution, to move this contempt proceeding to the floor, and I yield back.
Well, thank you I want to thank you both very much for your testimony. Let me just say that Chairman Thompson raised the issue at the beginning of his testimony that what you're calling for here today should be something that we ought to be able to bring to the floor and get unanimous consent on, and yet we can't. And you know, I'm puzzled by the fact that there doesn't seem to be universal outrage over not only what happened, but what we continue to learn, in large part thanks to the efforts of your committee. And I look around this Rules Committee hearing room here today, there are staff members who I know were here that day. Many were forced to hide, fearing for their lives. There's some journalists that were here who bravely stayed to try to cover the unfolding events. Also, I'm sure wondering whether or not they would be the focus of attack. You know, I mean, I was, as one of the last people off the House floor that day, and when I walked into the Speaker's lobby, I came within a matter of a few feet of the door. I could see through the glass this mob banging their fists, trying to break the glass to get at us. I will never forget that day, and not to mention the fact that 140 Capitol Police officers were injured that day, people died that day, and yet it seems that there are some who don't see the urgency in establishing all the facts and holding those who may have been responsible for this terrible day accountable. I can't quite wrap my brain around that. I can't quite understand that because there's no excuse for it. And you know, this lack of curiosity about the truth is stunning to me. And I appreciate that the work of this committee. I appreciate the fact that people are cooperating with the committee. I mean, hundreds of witnesses have cooperated, and so we will get to the truth. But the idea that we should just kind of turn a blind eye and say, well, you know, these people don't want to cooperate, so that's fine with us. I mean, we talk about precedent setting, that somehow we don't have the right to do oversight, we don't have the right to get to the truth. I don't, you know, I just remind everybody, I think history is watching us right now. And we better get this right for the sake of our country. So I thank both of you for your testimony. I yield to the gentleman from Oklahoma.
Thank you very much, Mr. Chairman. I just have one question, actually, for Chairman Thompson. I'm just curious. Congress has sent a number of these criminal contempt subpoenas to the Department of Justice. The Department of Justice acted on one, an individual that was not working at the time for President Trump. I'm curious if you had any communication with them. I know we've sent others down there. We've not yet seen action. Has there been any action between the Select Committee and the Department of Justice discussing this?
No. Once, Mr. Ranking Member, we finish our job, we turn the product over to the Department of Justice, and they decide to move from that point.
Okay, so you have no knowledge what that decision would be or what the time frame might be. Thank you very much. That's all I need, Mr. Chairman.
Mr. Torres.
Thank you, Mr. Chairman, and thank you so much to our witnesses for being here and for continuing to show heroism and commitment to our Constitution and to this wonderful building that we call our workspace. You have been through 650 witnesses, and very few of those have failed to do the right thing when called to testify. That is a good thing. You are here today for the fourth time for those bad apples that refuse to do the right thing and come before the committee and testify, or plead the fifth if they feel compelled because they were too close, too culpable. Most Americans were horrified by the events of January 6th and the blatant and criminal attempt to overturn the results of a free and fair election. I wonder how my colleagues on the other side of the aisle would feel if instead of red hats and red shirts, there would have been blue shirts and blue hats after President Trump was elected. Let me tell you, there were thousands of pink hats that descended on DC. And I was one of those people out there. Outraged that the man that we had just elected had no issue with grabbing women by the P word and had sexually assaulted so many women before that. But we demonstrated peacefully as Americans under one flag. We stood together and we complained about how bad the election was and about the long lines and about the many polling places that were shut down, completely shut down, in an attempt to prevent people that look like me and like you, Chairman Thompson, from voting. And they succeeded. But we did not come to this Capitol and assaulted you or our law enforcement officers. Instead, I put on my best dress and a smile, and I went to the inauguration because it was the right thing to do, because it was more important for us to stand as Americans and witness a peaceful transfer of power, like it or not. I want my vote to matter every time I go to the polling place, whether I'm on the ballot or not. But I want your vote to matter too, no matter how you look, whether you're a naturalized citizen like me, or you are citizen by birth, like many of you in here. You deserve to have your vote counted. You deserve to be able to cast your ballot. But here we are, once again. Some pretending that they are patriots. It is so offensive to me that you would pretend to be patriots and refuse to defend our Constitution because you're a sore loser. Because Americans were fed up with the guy that you put forward as your best choice for president. Americans were fed up with the hatred against every person of color. Americans were fed up with the nonsense. And Americans voted. And no matter how many polling places you closed, no matter how many hours they waited, they voted by the thousands. How can you call yourself a patriot because you support one man? But how do you ignore the fact that you are an American and that as an American, your job is to defend our Constitution? It is like the best example that I can give, it is like voting against my colleague's marijuana bill, but yet boasting about attending an orgy and witnessing colleagues using cocaine and failing to report that to ethics, even though you know that it is illegal and that it could be a violation of not only ethics, but the fact that that person using those drugs can compromise information that is made available to those members. How do you call yourself a patriot when you vote for that and support the other? I am an American by choice, and I am very proud to be here today among so many heroes in the press, across the table from me. And I hope that we could identify more heroes to stand up for our nation, because we're in a very, very fragile state right now. With Russia and Ukraine, with so many dictators around the world, it's time to choose our country, our flag, and our Constitution. I support this measure. Thank you for bringing it before us. I support the work of the committee. And again, if there's anything that I can do to help you, please reach out to us. And I yield back.
Thank you. Dr. Burgess.
Thank you, Mr. Chairman. Mr. Thompson, I just had a question really similar to Ranking Member Cole's question. We've been here before. You have issued these contempt citations, and the result of that is we're waiting on the Department of Justice. Is that correct?
As I said, all we are required to do by the resolution is to develop the evidence, and if the committee, in its wisdom, chooses to bring contempt, we do it. After that, it is the Department of Justice's responsibility after that.
Okay. And the acknowledged receipt of your request?
Yes.
Thank you. Mr. Perlmutter.
Thanks. Just a couple questions. In pursuing Mr. Scavino, Mr. Navarro, I mean, how many attempts did you make to get them to come in, testify, turn over documents? I mean, any estimate on that?
Well, I can give you the specific. Each one received a letter before we issued the subpoena. Subpoena was issued. In one instance, we negotiated with Mr. Scavino's lawyer for quite a while. And at some point, it became obvious he wasn't coming in. Mr. Navarro never responded at all,
Ever?
never,
Just ignored you completely?
absolutely.
And I think we've had a couple other instances, you mentioned that, but, I mean, you said in dozens and dozens of other cases, people have responded, have either come in and asserted their rights, or come in and answered and turned over documents. Is that true?
That's correct. We've interviewed over 700, we've had depositions of over 700 witnesses. And for the most part, everyone's cooperated with us. Some we're still in the process of working with, but nothing as flagrant as these two gentlemen here.
So you've had over 700 with it. I think we've issued a couple other contempts out of this committee and then off the floor. And now these two out of 700 requests, and they don't give you any reason why. You said they haven't asserted a privilege, they haven't even come in to assert their privilege.
That's correct. One did nothing, the other alluded to it, but that privilege assertion obviously comes with some authority by the current president. And President Biden has indicated he would not assert any of those executive privileges.
Well, I think this comes down to what the chairman was talking about, which is uncovering the truth. Now, in my opinion, we have a massive betrayal of the country here and the way we function and the way we operate. And the ability of each and every American to have a say in how their government is built and developed. And I'm going to support this this request for these subpoenas. I just appreciate the two of you and your committee's pursuit of protecting the Constitution and the rule of law. And with that, I'll yield back.
I think Vice Chair Cheney wanted to add something.
Please.
No, that's all right. I think it is important to make sure the record accurately reflects the number of individuals who've actually been held in contempt. So Steve Bannon was held in contempt, and the Department of Justice indicted him, and his trial is coming up, I believe, in July, and he's the first Department of Justice indictment for criminal contempt in over 40 years. Mr. Meadows was held in contempt. The Justice Department is still working on Mr. Meadows, and as the chairman said, that's up to the Justice Department. We obviously have our very clear views about that. Mr. Clark, who we came before this committee to discuss the possibility of Mr. Clark being in contempt, once we did that, Mr. Clark then asked to come in, and he came in and asserted the fifth. And so he has not been referred. We did not go to the full House with that. So I think the notion that somehow, I'm not sure what my colleagues on the Republican side are getting at in terms of numbers of people referred to the Justice Department, but this is a very clear case. Two individuals with clear information that's relevant to the committee, and there is no standard under law by which you can simply say, I'm not coming because somebody told me not to, even if that person's the former president of the United States. If they believe that answers to those questions will be covered by executive privilege, then they need to come in and say that. You can't just refuse to respond to a congressional subpoena. So this is really a very clear case, and nobody should be playing politics with it.
Right, and I would just thank you for adding that. I mean, the notion that we would just turn a blind eye, as the chairman said, to try to just forget about it, sweep this under the rug, is just so appalling and so disturbing. I just thank you again for pursuing this. I yield back.
Thank you. Mr. Reschenthaler.
Thanks, Mr. Chairman. I appreciate it. I'd like to associate myself with the remarks of the ranking member. Additionally, I'd ask for unanimous consent to enter into the record a letter from Mr. Scavino's attorneys dated 25 March 2022.
Without objection.
Thanks, Mr. Chairman. For brevity's sake, I'd like to explore this letter, but I'll do it on the next panel and yield back.
Okay.
Thanks.
Gentleman yields back. Mr. Raskin.
Thank you, Mr. Chairman. I heard the distinguished ranking member in his opening, and he did not take issue with the DC Circuit position on executive privilege or the Supreme Court. He did not seem to dispute the facts of the deadly insurrection that overtook this chamber and our people on January 6th, and the worst explosion of mass violence against Congress since the War of 1812. But I did hear him call the Select Committee partisan, I think, and please correct me if I got that wrong. But I think he, and so I wanted to pursue that for a moment, because it does seem like all of the legal arguments, the executive privilege, separation of powers, all of that's fallen away. Everybody sees they're losing in court. Nobody can take that seriously. But there's this claim out there that the committee's a partisan one. So I wanted to pursue that with both of you, because I think you are two members who are of different political parties, which I think immediately refutes the claim that it's a partisan committee. But you also are two members who have acted in some ways outside of the will of your own parties. Both of you are, in some sense, transpartisan, we're supra-partisan heroes. I mean, Mr. Thompson, before the House of Representatives created the Select Committee, I believe you were the person who was negotiating for an outside commission modeled after the 9/11 Commission. And I remember hearing a lot of grumbling among Democrats because you negotiated a successful bipartisan agreement, I think with Mr. Katko of New York, for an outside commission made up of 5 Republicans, 5 Democrats, equal subpoena power right down the middle. And if I understand it correctly, you basically agreed to what the Republicans were asking for. Is that right?
That's correct, as well as no member of Congress could serve on that nonpartisan commission.
So not only was it going to be nonpartisan and independent, that commission was going to be non-congressional, right? It was going to be former secretaries of state, former secretaries of defense, distinguished people across the board, like the 9/11 Commission. And I believe that that was originally initiated by Mr. McCarthy, wasn't it? The minority leader did he not send his emissary, Mr. Katko, to negotiate that with you?
That's correct, and you're correct. Some of my more progressive Democratic colleagues took issue with the negotiation.
They said, the Democrats are in the majority, we should have a majority on that commission, and you said no. You said it's far more important to pursue the truth in an objective way, and we'll have a balanced commission. This is my recollection.
That's correct. Plus, it was clear that when the insurrection of January 6th occurred, they wanted to hurt anybody they got their hands on. So you were a Democrat, Republican, or whatever. And I felt a calling beyond the partisanship so that we could...
Well, some of those insurrectionists were hunting for Nancy Pelosi, and we have footage within our committee of people saying exactly what they were going to do to Nancy Pelosi, but there were clearly people who wanted to end her life. There were others, we saw them chanting, "Hang Mike Pence, hang Mike Pence." The words are still ringing in my ears from that day. So that was a bipartisan hit squad, wasn't it, that came in with the insurrection?
No question.
They were looking for Democrats and Republicans. They wanted to overthrow American constitutional democracy. So you came up with Mr. Katko with this commission, and please tell me what happened, because what I read in the newspaper was that Donald Trump said no. He didn't want any investigation at all of the assault on American democracy. Is that right? I mean, that's the understanding I've got. If something else happened, please correct my misunderstanding.
You're correct. We accepted two issues from Mr. McCarthy. One is the equal number of members. The second is that there had to be no members of Congress on it. So we accepted...
And equal subpoena power, right?
Equal subpoena power. And so after we accepted it, formalized it, the former president decided he was against that. And so Mr. McCarthy came out.
He changed course, didn't
He
he?
came out against his
It was a
own
U-turn.
his
He did an
own
about-face,
recommendation.
and he opposed the very commission that he had initiated and advocated for. Is that right?
That's correct.
Okay, so then we're forced in the House of Representatives to say, all right, well, we're not going to let this go, as Mr. Perlmutter says. We're not going to bury this in the sofa. We're not going to sweep it under the rug. We're going to have our own select committee. And that's what this is. And I see a Democratic chair and a Republican vice chair. Ms. Cheney, are there any other committees or subcommittees in Congress you're aware of that actually have one Democrat and one Republican working together the way that you and Mr. Thompson are?
I'm not aware of any. I also would like to say I'm extremely proud of the nonpartisan way, as you know, Mr. Raskin, our committee is operating, the nonpartisan way our staff on this committee operates. And, you know, I spent a lot of my life, because I grew up, you know, with a father who was involved in politics.
Which side was he on?
Bush v. Gore, we can talk about it later. You know, when I grew up and I watched public servants and I watched how public servants in this country operated, and when people would say to me, you know what, politicians, you just can't count on them, you just can't trust them, I would defend them, and I would say, no, the vast majority of people that I know, and I know many personally, do the right thing. And they're here for the right reason in this body, and they care about the country. And when they are called to act in a way that is inconsistent with their political desires, political wishes, they will. And I spent most of my life saying that. And one of the most disappointing things about this period of the last 14 months has been the extent to which, when the chips were down, my colleagues did not meet the test. When the chips were down and when you were called to do what you know is right, instead you played politics. And you continue to do it in here today. Continue to do so. Mr. Scavino and Mr. Navarro are obviously and clearly in contempt. There shouldn't be anything political about the fact that they're in contempt. And as the chairman said, we should be able to move this on unanimous consent. But our country demands better. Our country demands elected officials who are serious, elected officials who know the difference between politics and your oath of office. Our country demands that, and the future of our republic demands that. So I think it is absolutely clear what the right thing is to do with respect to this, and with respect also more broadly to investigating the attack of January 6th, proposing legislation that will help ensure that it never happens again.
Well, I appreciate that, and I've got to say, as a person who's fortunate enough to serve under both of you on this committee, it is the most bipartisan committee I've ever been on. It's the one committee, Mr. Cole, that I serve on that doesn't begin with, well, this one may be a partial exception, but most of the committees I serve on start with an hour of partisan polemics and diatribe where people are just slashing at each other and attacking each other, and that's really not how the January 6th Select Committee works. We're rolling up our sleeves and getting down to work. We're trying to determine the events of January 6th, the causes behind them, and then what we need to do to fortify American democratic institutions moving forward against future coups, insurrections, and violence that would overtake our institutions. So not only is this a bipartisan institution, it is a model bipartisan committee, and I hope it's one that some other committees can learn from in terms of people working together in a truly bipartisan way. I just have a couple more questions, and one for you, Ms. Cheney. You mentioned that something very important, which is the vast majority of people we've wanted to talk to have wanted to talk to us. I believe we're now over 800 witnesses who've come forward. And I dare say the majority of them are Republicans, people coming forward to talk because they were involved in a lot of the activities. A lot of people describe it as a patriotic duty to come forward to tell the Congress of the United States about this assault on our democracy. But, Ms. Cheney, you also talked about heroes out there, kind of unsung heroes in the land, who stood up for the Constitution and the rule of law. There were people like Secretary of State Brad Raffensperger in Georgia who refused every effort to intimidate him to concoct phony election results. There were election officials in Arizona who did the same thing. Not all of them were Republicans. Some of them were Democrats too. That was bipartisan. But say something about that, I think, just to debunk this final myth that there's something partisan about the investigation going on.
Well, it's one of the things, Mr. Raskin, that gives me real hope for the future and gives me tremendous hope for our republic. And that is the individuals at all levels of our government who resisted the pressure to do the wrong thing, resisted the pressure to violate the Constitution. Many of them are young people. They are young people who, some of them people that we have talked to from the campaign or from the White House, who know what was going on was so dangerous. And they give me real hope. We've seen that among the young people here in the Capitol, the people this young staffers who were here that day. They know right from wrong. All of us know right from wrong. But the young people who will stand up and who will say, this is not America. We must be a nation that is characterized by a peaceful transfer of power. That is what matters and what, as I said, gives me hope. I think it's also crucially important to remember, as a number of my colleagues have said, our institutions don't defend themselves. We were dependent upon the people that you've mentioned at all levels of our government. And we were dependent upon the Capitol Police. We were dependent upon the Capitol Police. If you have any question, and some of my colleagues seem to have forgotten, if you have any question about what happened that day, go watch the video of the hand-to-hand combat that happened in the tunnel that the president-elect walks out as he goes to take the oath of office. Go watch that video and understand that if it hadn't been for the men and women in law enforcement, Capitol police officers who fought in that bloody battle as police officers were dragged out of this building, as police officers were crushed, while former President Donald Trump sat in the dining room next to the Oval Office watching television. Go watch that and think to yourselves, what would have happened if the men and women in uniform who defend all of us in the Capitol Police and the Metropolitan Police Department, if they hadn't done their job? We would have had thousands more angry, violent rioters in this Capitol. We would have had a far worse constitutional crisis. So don't think that you can whitewash this, and don't think that you can maintain your character and your honor and your duty if you attempt to whitewash what happened.
Well, let me ask you one final question, and then, Mr. Chairman, I have a final one for you. But I had a conversation on the floor with a GOP colleague the other day who said to me, well, it's easy for someone like Liz Cheney, whose father was the vice president, who has a big name, to take on the powers that be. It's easy for Mitt Romney to do it, but it's not so easy for people who are going to face the wrath of Donald Trump. He could spend a lot of money against them, he could have somebody run against them, and so on. What do you say? You're you've taken a very outspoken and some would say brave stand here, but at least I've heard from one Republican colleague, you're in a unique position. Are you in a unique position? Is it impossible for other Republicans to take a stand against what Donald Trump has been lying about and what he's been doing to the country?
Well, I don't view it as bravery. I don't view it as courage. I think what the Capitol police officers faced that day when they fought, that's bravery. I view this as duty. And these offices that we hold are positions of public trust. We swear an oath under God to the Constitution. It's not a ceremonial oath. It is an oath that has to mean something. And so you don't have a choice. When something has happened that is such a flagrant violation of the Constitution, and it's not just what happened on that day. It is an effort by the former president to overturn an election, to use multiple tools and sources of pressure to try to stay in office, to try to delay our counting of electoral votes. Ultimately, the violence that we all lived through, you have a duty to stand up against that. We're not bystanders. And if people are sitting in these seats because they just want to sit in these seats, then they're not fulfilling what is the most important responsibility in positions of public trust.
Mr. Chairman, I think you've convinced a lot of people about your position on these contempt citations. These two people, you take Peter Navarro. Navarro was the trade advisor who got involved in all of these January 6th events, and then blandly, vaguely says, well, the executive privilege is not mine to waive, which of course is true. Neither is it his to assert. It belongs to the President of the United States. And Joe Biden said he's not asserting executive privilege for him. And then Navarro says, oh, well, it's a former president, but that former president hasn't asserted executive privilege for him. Have we heard anything from Donald Trump asserting executive privilege on behalf of Peter Navarro?
We have not.
So, and any court would say exactly what the courts have been saying before. Even if Joe Biden was here trying to assert executive privilege, a court would look at it and say, wait a second, executive privilege is for advice rendered by a federal advisor to the president on a subject matter they're working on. So like trade policy, if we were subpoenaing him to come in here and tell us trade policy secrets or something, it's got nothing to do with that, right? We're not trying to talk to him about what he was really working on. We were subpoenaing him to talk about his political campaign activities, his political activities, or his criminal activities. And none of those are covered by executive privilege, right?
Well, that's correct. The other thing is, both of them were paid by taxpayers. They had no real mission in a political sense because the law prohibited it.
The Hatch Act says they couldn't be doing that. So by definition, you're absolutely right. They couldn't have been doing their jobs at that point unless they're confessing a crime under the Hatch Act.
And
right?
So we wanted to bring them in and ask questions. And we could not get them in. And that's why we are here today.
Nobody's asserted an executive privilege on the behalf, not a former president, much less the current president, who specifically said no. And in any event, anybody can look at it and see that the executive privilege wouldn't apply. And yet, some people seem to want to set a precedent that anybody can just blow off the Congress of the United States. It's incredible to me that we've gotten to that point. But let me ask you this. What are they hiding? That's what America wants to know. What are they hiding? We have hundreds and hundreds and hundreds of people who come in to testify, to give us their complete testimony, to talk to the committee, and yet it seems like the closer that we get to Donald Trump, Steve Bannon, Mark Meadows is kind of doing the hokey pokey, 1 foot in, 1 foot out, but the closer we get to him, the more we find people who just want to blow off the committee. Why? What are they hiding?
Well, part of the charge we have as a committee is to investigate what happened on January 6th. And obviously, part of that commitment is to talk to the people in the president's circle. We believe this concept that the election somehow was fraudulent was wrong, that we've not, as a committee, we've looked in many circles to look for any illegality. We've not found it. I tell you what we have found, Mr. Raskin, a lot of patriotic Americans who would conduct elections year in and year out, who are absolutely upset that the former president would say that they cheated. And many of these officials were Republican officials. And so they have now said, I'm not going to work in another election, if this is what it's come down to. And that's the other part that the vice chair was talking about, is the fact that with what has occurred, it has discouraged so many Americans from staying engaged in the political process, that our work as a committee is so important to the future of this country. We pick our leaders at the ballot box. We're supposed to settle our differences at the ballot box. And what occurred on January 6th is not who we are as Americans.
Well, I want to just thank you both for the very bipartisan way in which you've conducted this committee and this remarkable and important historical investigation. The big lie remains a threat to this democracy. We must destroy that big lie with the facts and with the truth, and we have to stand up for everybody that's making democracy work. I yield back to you, Mr. Chairman.
Thank you. Ms. Fishbach.
Mr. Chair, I have no questions. I'll yield back.
Someone yields back. Ms. Scanlon.
Thank you, Chairman Thompson and Vice Chair Cheney, for your absolutely vital and patriotic work on behalf of our country. This is the fourth time you've had to come before this committee to seek a contempt resolution, with only the president's closest associates having the gall to defy a congressional subpoena, to share what they know about a physical assault upon this nation, this building, and the Constitution. The fact that over 800 people have been willing to appear, whether voluntarily or pursuant to a subpoena, shows just what outliers these members of the former president's inner circle are. In order to move past the attack of January 6th, we need to hear the truth, and we need accountability. We've been saying that since the wee hours of January 7th, when the insurrection was halted and the lawful election of President Biden and Vice President Harris was certified. I was struck by something the Vice Chair Cheney said, that the White House, the former president, and his staff were warned. They were warned that there'd been no fraud in the election. They were warned there was no legal basis for the challenge. They were warned that the January 6 rallies were likely to lead to violence. I would also add that they were warned by congressional and legal authorities that the administration was legally obligated to preserve documents regarding the events that occurred throughout the transition period. We've heard about the numerous attempts of the Select Committee to engage Mr. Navarro and Mr. Scavino, to engage with them, but they've refused to show up or even to assert claims of privilege. As Chairman Thompson said in his statement, come in, take an oath, take a seat. I would add, take the fifth if you must, as it seems increasingly likely they may have to. But we don't have time. This country doesn't have time for this contemptuous and contemptible behavior. Navarro and Scavino both had intimate knowledge of and involvement in the events leading up to and on the day of January 6th. It's well within the Select Committee's right to subpoena them for information. I'm so very proud of the difficult work the Select Committee is doing. I know you're making a lot of progress with your investigation, and I and the rest of the country look forward to your findings. I strongly support the contempt resolution included in today's rule. I urge its expeditious passage and its expeditious prosecution by the Department of Justice. Time's wasting. I yield back.
Thank you. Mr. Morelli.
Thank you, Mr. Chairman. Frankly, I'm always struck by a sense of sadness when the two of you show up here. Not that it has anything to do with either of you, but it really is sad. There's nothing to celebrate in any of this. I'm not going to say anything that hasn't already been said. But for me, you know, we sometimes get into really sort of nuanced and important arguments here. But for me, this is pretty simple today, what we're doing, right? You have an election. Joe Biden won that election. It was a close election, but it's an election he won. I don't, people may dispute it, but despite repeated efforts to demonstrate any kind of fraud involved, no evidence for that. Dozens of lawsuits, all unsuccessful, that led us to January 6th and certification. We're gathered here to do our constitutional responsibility. The Capitol is attacked by hundreds of people, results of the death of five individuals, subsequent suicides. The toll continues to to rise. And so as a consequence of that, we establish your committee. And members are selected after going through a process that I think Mr. Perlmutter described well of looking at alternatives, but we end up with what we end up, which is a committee that has subpoena power to compel testimony of individuals that you believe can in some way enlighten us all on what happened. The two individuals, the subject of the resolution before us, clearly the committee has decided their work is of interest. One individual even wrote a book on the subject, or at least a part on the subject, so clearly has something to say about what happened and could shed some light on it. And yet, despite repeated attempts to ask those individuals to give testimony, they refuse. The committee has the power of subpoena. I think it's Title II, Section 192 of the U.S. Code, makes it a federal crime to willfully defy a congressional subpoena, which has been lawfully issued to both gentlemen. I'm not sure what would compel me to oppose your recommendation. So you have the power to do it. Mr. Navarro and Mr. Scavino may withhold their testimony, but they may not do it without violating the law of the land. So I guess it's their choice to do, but it's not a choice that doesn't carry consequences, and violating the law should result in the referral to the Department of Justice. And it seems to me, if we don't proceed with this, the law is meaningless. If we don't proceed here, I'm not sure how we would suggest that Congress has any power in future investigations, in future endeavors when we issue subpoenas. So it's not only what we do here, as important as this is, and I can't frankly think of anything more important than what you're doing and what you're asking the two individuals to come and testify for, but it also sets the precedent in the future. Can you just willfully ignore subpoenas of the Congress, willfully ignore the law? And I'm not sure then the public should ever have any confidence in what we do. If you're not going to say there's got to be accountability for willfully ignoring the Congress that has lawfully extended these subpoenas, and I'm not sure how we would defend the Constitution. What will we say to our children and our grandchildren? Will there even be a Constitution to defend? I often think back to Ben Franklin at the Constitutional Convention, was concluding the second Congressional, and was asked what we had, and he said, what have you given us? And he said, a republic if you can keep it. He was talking about moments like this. Are we going to keep it? And I fear for the life of me that we're hanging by a single thread at times. And so the work you do, and I don't know that anything I've said isn't factual. I don't know that, I mean, it's pretty clear to me. As I said, I'm not particularly sophisticated. I don't understand the nuance. This is pretty much straightforward. And so we need to save that republic, and we need to make sure that we leave it to generations to come. So I'll support the rule, the resolution, and I yield back.
Thank you very much. I think Mr. DeSagne has no questions. Ms. Ross.
Thank you, Mr. Chair, and thank you both to the chair and the vice chair of the January 6th committee. Our nation owes you a huge debt of gratitude for your service and for what you're doing to preserve our democracy. Our nation can't forget the events of January 6th, nor can we minimize them. The attack on the Capitol and on our democracy was a direct assault on this country and its underlying principles. And the chaos sown by President Trump and his accomplices was an open invitation to undermine our national security and a signal to the world that our republic is in the midst of a crisis. Consequently, we have to take significant and deliberate steps to demonstrate our nation's steadfast commitment to the peaceful transfer of power. This means we must hold those responsible for this attack accountable for their actions. And the individuals who participated in, aided, or abetted the insurrection are obligated to comply with subpoenas duly issued by the Select Committee. When individuals do not comply with congressional subpoenas, we have not only the authority, but the responsibility to use the powers of this body to hold them accountable to the will of the people. And that's what we're doing today with Mr. Navarro and Mr. Scavino. It's critical that Congress pursue its investigation to the fullest extent of the law to ensure that no individual or group can get away with attempting to undermine the democratic process. We're a nation of laws, and our system of government is designed to afford all Americans the right to determine our nation's future through free and fair elections, not through force, disinformation, intimidation, or obstruction. For these reasons, I support the rule and the underlying resolution. I thank you so much for your service. Thank you, Mr. Chair. I'll yield back.
Thank you very much, Mr. Neguse. All right, well,
Nope, no questions, Mr. Chair. I
no
yield back.
questions? Okay, all right. Thank you very much. Let me again thank both of you for appearing before the committee. Thank you for your commitment to the truth. This shouldn't be this hard. The fact that it is, I think, is a terrible statement about the current state of our politics. But as I said at the beginning, I mean, we better get this right. So again, thank you very much. There are no further questions of this panel. You are free to go. Thank you. I'd now like to call up the Honorable Kelly Armstrong of North Dakota. You could, yeah, just make sure your microphone is on, that's all. You need your glasses and your microphone on. You have no idea. Yeah. You may proceed anytime.
Thank you, Mr. Chair. You know, in December of last year, I opened my testimony to this committee by stating, I am not here to weigh in on the actions of Mr. Clark or any other individual on the January 6th or the months prior. And I reiterate that statement today. But my previous testimony describes what Mr. Scavino's counsel has now referred to as the Select Committee's pattern and practice of intimidation and disregard for the rule of law. I emphasized how the Select Committee's inappropriate methods undermine the legal principle that every single person anywhere in the country has a legal right to object to a subpoena. Yet the Select Committee has publicly denied that the recipient of a subpoena has any option but to submit fully to their demands. Anything less will be met by condemnation and criminal referral. The committee continues to advance criminal contempt resolutions despite its engagement in various civil cases that implicitly acknowledges the proper branch to settle such disputes is the judiciary. Mr. Scavino's contempt referral is premature, just like the previous contempt resolutions advanced by the committee. Mr. Scavino has consistently engaged with the Select Committee in an attempt to clarify the scope and topics of an overly expansive subpoena. He has consistently asserted his positions, which include that the subpoena is too expansive in scope to allow him to properly prepare and provide competent testimony, a point which assumes increased relevancy considering the Select Committee subsequently requested additional testimony on materially different subjects. That communications conducted via personal device fall under President Trump's assertions of executive privilege, and that the D.C. Circuit Court's holding in Trump's v. Thompson only involves specific documents and not a subpoena for testimony. It is my understanding that Mr. Scavino's position on Trump v. Thompson's remains unchanged despite President Biden's decision not to assert executive privilege specific to Mr. Scavino's communications. As I stated previously and repeated previously, the question before us today is not whether you agree with Mr. Scavino's position. The question is whether you recognize Mr. Scavino's right to challenge a subpoena. Congress's role is not to decide such disputes. Our decision is whether this pending criminal referral is premature, considering that Mr. Scavino has sought to engage the Select Committee and no court has upheld the subpoena's lawfulness. To refer an individual for criminal prosecution under these circumstances is unjust. The Select Committee's actions are even more indefensible when you understand that the subpoena contains 15 matters of inquiry, which are broad and ill-defined. Yet through subsequent correspondence on November 9th, the Select Committee included 18 additional matters of inquiry for a total of 33. Not to mention that the Select Committee reserves the right to question Mr. Scavino about any and all other topics. Mr. Scavino's correspondence raises objections to these additional matters of inquiry, objections which the Select Committee has never substantively addressed. The 9th letter responding to Mr. Scavino's objections, the committee dismissively states that the items identified are unquestionably pertinent to the Select Committee's jurisdiction. Mr. Scavino correctly responds that the committee's failure to substantively respond and only offer blanket assertions of jurisdiction are the reason the parties have not come to terms to obtain the testimony. And what exactly are we arguing about? Is the matters of inquiry in the subpoena and the contempt referral? Are we also discussing the additional matters of inquiry that the committee sought outside the scope of subpoena, which Mr. Scavino has consistently objected to? The subpoena is not narrowly tailored. Your contempt referral is not narrowly tailored. However, both are narrowly tailored compared to the complete list and correspondence of inquiries sought from Mr. Scavino. The Select Committee's refusal to engage with Mr. Scavino's attempts to specify the subpoena is buttressed by the intimidation of criminal contempt referrals upon the head of any individual who does not submit. The committee demands of obedience were parroted by the House Democratic Caucus's chief whip in a little-noticed interview this past Sunday. He stated that an individual does not have a choice as to whether to comply with a subpoena from the committee. Again, the recipient of any subpoena absolutely has a choice. The individual has a choice and a right to contest the subpoena. The court decides whether the subpoena is enforceable, not the Select Committee. And continued public statements to the contrary further undermine the Select Committee and Congress as a whole. A member of the Select Committee recently said, "Attorney General Garland, do your job so we can do ours." Another member of the Select Committee, in referencing the Department of Justice's supposed duty to act on criminal referrals, without enforcement of its lawful process, Congress ceases to be a co-equal branch of government. Pass as many criminal contempt referrals as you want, because criminal prosecution is not enforcement of a subpoena. It is punishment. The Select Committee has enforcement mechanisms to enforce a subpoena. It has just chosen not to use them. It has not been willing to specify the scope of the matters of inquiry, nor has it been willing to enforce the subpoena in civil suit. Perhaps we should all stop trying to tell Attorney Garland how to do his job. It's clearly not working. The executive branch is a co-equal branch of government. The Department of Justice is supposed to exercise prosecutorial independence. At least that is what many of you decried when claiming the Trump DOJ was politicized. Yet, as we are witnessing, DOJ's independence is often disregarded when politicization of prosecutions are advantageous to House Democrats. I was in the room when you held Bill Barr in contempt for not violating the law. He redacted a small fraction of the Mueller report in compliance with longstanding DOJ practice and controlling D.C. Circuit precedent concerning the confidentially grand jury material, and who still held a sitting Attorney General in contempt. And now you say that the Department of Justice has a duty to act on this referral and others that we have sent. They do not. Just like they did not with Eric Holder, and just like they did not with Lois Lerner. There are even reports that the president wants the Attorney General to act less like a ponderous judge and more like a prosecutor who is willing to take decisive action over the events of January 6th. That is in stark contrast to the president's public comments about DOJ's independence when introducing A.G. Garland. Referring to A.G. Garland's loyalty, he said it's to the law, the Constitution, and the people of this nation. All of this has resulted in Attorney General Garland saying that he will not respond to outside pressure. I appreciate that, and I hope he means it. Perhaps we shouldn't tell him what to do while repeatedly alluding to violation of specific criminal statutes in direct contravention of controlling Supreme Court precedent on the purpose of congressional subpoenas. Even if the next line is usually a resuscitation of the committee's supposed legislative intent, which is a feigned attempt to comply with the exact Supreme Court precedent that has just been disregarded. The DOJ has a duty to prosecute cases it sees fit under the law, not to do the bidding of this select committee or any other for that matter. With that, I'll yield back.
Thank you very much. Appreciate you being here. I don't really have any questions, Mr. Armstrong. I appreciate you coming before the committee. I don't really know you very well personally. You've been before the committee a few times, and we appreciate your appearances here. But I have to just tell you that listening to your presentation today in the face of all that we know and what we're trying to get to here, which is the truth, is kind of disheartening and depressing to me. I get it. I mean, making excuses or trying to run interference for why we shouldn't subpoena these individuals, whatever, but as if somehow that Navarro and was somehow a victim. I don't really get that. I mean, the victims were the people who were hurt here on January 6th. The Capitol Police who were beaten, some lost their lives. I mean, the staffers who were traumatized, the reporters who are traumatized, risked their lives. Those were the victims. Our democracy was what was victimized here, and it just stuns me that in the aftermath of that terrible event, there doesn't seem to be a lot of outrage about what happened. I have a tough time dealing with that. That was a horrific day, and the focus of that day was to overturn a free and fair election, to nullify the will of the American people. And this building was attacked. People got hurt. People died. And so, I appreciate the statement, but I don't think we should be about the business of defending those who may have been responsible for that terrible act on the Capitol and our democracy. And I think we all ought to, rather than trying to run interference so that we can't get to the truth, ought to be spending all that energy trying to get to the truth, making sure that, that everybody who may have some information provides that information. Because I think we know what the agenda is by those who do not want to cooperate, and that is that they're hoping to run the clock out. They're hoping that maybe the election will result in a different majority and that the attempt at getting to the truth will no longer be a priority. But in any event, I appreciate you being here, but I would be less than honest if I didn't say that I was a little bit disappointed with the presentation. Mr. Cole.
Thank you very much, Mr. Chairman. I don't share the disappointment, so. Our Democratic colleagues have repeatedly and rightly stated that President Biden did not assert executive privilege in the two cases before us. It's my understanding, though, that former President Trump did. What have the courts said on the question of whether or not a former president can assert executive privilege?
Well, first of all, I think thank you, Mr. Cole, and not only that, but Mr. Scavino's first letter engaging with the committee on November 5th, 2021 says that as well. And the ruling probably that you go back to, which is keep in mind that Trump v. Thompson was very narrowly tailored to the National Archives and not testimonial. And the question on whether a former attorney or whether a former president has privilege actually goes back to the Nixon case. And in very specific purposes for criminal prosecution, they say that can be waived. But the true answer to that question is, it should be ruled on by the court. Even the Nixon case has discrepancies as to what extent prior presidential privilege applies. But it's not nearly as clear as they would have you believe.
If a president, former or current, were to instruct an individual to invoke executive privilege, do they have any sort of legal duty to do so?
Yeah, I think in the numerous correspondence between Mr. Scavino's lawyer and the committee essentially says you put them in a paradigm of vagueness. Not only that, but because for twofold. One, the subpoena is significantly overbroad, but two, you're asking them to make a decision one way or the other in which they're potentially in violation of privilege or the committee's request.
Okay, and did the conduct and communications of the Select Committee allow for the individuals in question to be meaningfully prepared? And why would that be important? You touched on this a little bit.
Well, so, and this has been the case with all of them, but I think this one is even a little more interesting in that there's always the catch-all at the end where the committee says, we will ask about anything else, and anything you want to do, please provide a privilege log, which is just in contradiction to how this would go. But this one's really unique, particularly where we're at right now, because the original subpoena had 15 areas of inquiry. Subsequent correspondence that existed throughout the whole thing, about the only way in which the committee meaningfully responded was they expanded that to 33 areas of inquiry. They've never addressed the second subpoena. I don't know if the contempt rule, handles just the 15 areas that were originally subpoenaed, or all 33 now, but it's a pretty interesting place to be in when there's actually a subpoena issued and we expand the scope in the middle of that without ever addressing not only the overbroadness of the original parts, and also the additions, and now we're holding them in contempt. So it'll be interesting, I will say that.
In the report accompanying the resolution, did the Select Committee adequately demonstrate a sufficient showing of need and inability to obtain the information elsewhere? And why is that important?
Well, I think in a lot of cases, for a lot of this, and this again gets into the other side, but whatever, they have said they would make available whatever wasn't in the National Archives. And in my understanding, there has been no meaningful engagement from the Select Committee on the other side of that.
It's my understanding on several occasions, Select Committee continued to expand the scope of its topics that they wish to discuss. And one of the individuals named the resolution before us, why is that problematic?
Well, one, because I'm not sure, either the contempt order only covers what was in the original subpoena, which is patently unfair to the witness because it has been expanded in the meantime between that, or it incorporates things that weren't actually in the underlying subpoena, and both of those I would think are fairly problematic for a future criminal prosecution.
And you touched on my last question a little bit, but I want to sharpen it a bit. Is the Select Committee acting in a manner consistent with the principles of congressional authority and inquiry, particularly as it seems they continue to suggest that they are all-powerful and the final arbiters of any legal claim?
Yeah, the responses to this essentially is it's within the committee's jurisdiction. Current President Biden has not asserted privilege, and very little citation, very little backing for that, and very, very little meaningful engagement back and forth with somebody who is obviously trying to narrowly tailor and decide and get to the point of where they can provide what the committee is asking for.
Okay, yield back.
Thank you, Mrs. Torres. I have no questions. Dr. Bridget, Mr. Reshnathala.
Thank you, Mr. Chairman. I appreciate it. Mr. Armstrong, to pick up where the ranking member started his line of questions with some precedent. What I'm seeing here is two overarching issues. Number one is, despite what folks may claim, the law is actually unsettled on executive privilege. We can go through some of the case law briefly, but also the other issue is this committee outside the scope of Congress? Meaning, is it more of a criminal investigation, which is clearly not a legislative function? Or is it engaged in a truly legislative function, which is important because the case law talks extensively about whether the subpoenas are for other purposes other than a legislative function. So when we're talking about these issues in the case law, do you see those as the two glaring issues here?
I do, outside of the specific scope of, this specific subpoena. And listen, I'm not the person to contest that this committee has a valid legislative function. I think they do. I do think the rhetoric and we've had members of the committee reading criminal code on national TV about what is going on, how this works, and then throwing that throwaway line at the end about towards a particular legislative purpose. But so at least in the rhetoric and in the actions of how they try to, it's not enforce, penalize this is different.
But wouldn't you agree that Congress has the authority to investigate only for legislative purposes? So
yes.
Anything that, and
specifically, yes.
And then to that end, when Congress issues a subpoena, it can only be for a legislative purpose. For example, okay.
Subpoenas solely for for the purpose of sunlight are specifically held not to be a clear legislative purpose.
In some of the precedents that reference this are Quinn, Watkins, and McGrain. So for example, in Quinn, Congress cannot issue a subpoena for law enforcement purposes. Then you have Watkins. Congress has no authority to issue a subpoena to compel for the sake of exposure, just to expose and embarrass. And then McGrain, where it says Congress may not issue a subpoena in an attempt to, quote unquote, try somebody before a committee for any crime or wrongdoing. Given those three precedents, do you see this subpoena and the actions of this committee falling within the territory of those precedents?
I do, and I think the biggest issue is how they respond to any legitimate, real request for narrowly tailoring or moving on. And in fact, they did the opposite. They expanded it, and then when there was communication back, it was just like, we have authority. I mean, that's literally the answer, is we have authority.
It's an incredibly circular argument. And again, just the FBI and the U.S. Attorney's Office are the proper bodies to do an investigation that's criminal. Again, I'll say, if it's a legislative function, I get it, that's our purview. But for the criminal investigation, what's the proper authority?
Absolutely, it's the DOJ. And by the way, the proper authority to enforce a subpoena is civil court.
When we look at Mr. Scavino's case, and there's a few things that stick out to me. Number one is he actually has a letter from the president. Remember, it's the president's privilege to assert here. And two, he was a closer advisor to the president. And to go back to a president we haven't talked about, which is the Nixon case, the Nixon case said that the reason you have executive privilege is because those around the president have to be able to give candid advice, much like a lawyer would give a client, without the fear of that coming to light in the future. So given those 2 points, do you have any thought on Scavino's argument in particular?
Yeah, I mean, and I think it is not settled. And that, I mean, this is not just about a document production, and this is not just about testimony. It has both. And I think in both cases, it falls outside of the narrow exception in Trump v. Thompson.
When we're talking about Mr. Scavino, I know there was talk about the back and forth with his lawyers, et cetera. I think you were in the room when I offered a letter from Mr. Scavino's attorneys. By the way, has not been answered by either the committee or the White House yet. But that letter talks a lot about due process arguments. Are you familiar with all the due process issues? And if so, can you expand?
Sure, it's pretty hard to meaningfully prepare for a deposition when you can't get a meaningful answer, and the correspondence expands on the original subpoena, and the original subpoena is clear that they felt was overly broad, duplicative, and a lot of different issues. And they would go 45, 50, 100 days without getting a response, and then they get a response saying you must comply. The response from the committee would be you have 3 days to comply with this. There was no meaningful engagement that I am aware of on any of these issues. And you might not agree with these issues, but it's not I mean, it's a very cogent, very detailed legal argument that has been consistently made.
And you see a huge problem with the fact that the scope was constantly expanding, so it gave Scavino no opportunity to prepare?
Yes.
And what about the burden shifting too, where at one point the committee basically said, you hand over what you think is relevant? I mean, what are your thoughts on that?
And by asking or presenting what is truly a false choice about doing this and claiming privilege with very specific documents and limiting to a privilege log in order to comply with what you're asking without ever meaningfully engaging on what you're already disputing is absolutely burden shifting to the witness and forcing them into a position that is, in often cases, would be a distinction without a difference.
Are you familiar with the case U.S. v. Renicky? I might be mispronouncing that.
I'm not sure. I've read a lot in the last 3
Okay,
days.
so that's fair. So the U.S. Court of Appeals overturned a perjury conviction for somebody who, obviously Renicky, who was found guilty of lying to a Senate committee. But the court did that because there wasn't a quorum present in the committee. So does that jar your memory? Do you have thoughts on that? Because I feel like the due process violation, a lot of people just think we're talking about due process violations, but the court has held that even a quorum being busted is grounds for overturning a perjury conviction. Can you just relate that case to what's going on with Scavino?
Yeah, I mean, I just think that, I mean, listen, all of the courts have held in varying different degrees in how of this works. Your best option for any congressional enforcement conviction, civil enforcement, all of that, is that you're very narrowly tailored for a very specific purpose. And there's a real due process reason for that, because the broader in scope and the more expansive in scope, and when you deal with all of these things and then you expand it after the fact, it is very meaningful, it is very, very difficult to actually provide due process to the person who is coming in front of you, because the answer is, we want everything, all of it, we don't care. I mean, and that truly, I mean, is how that works. And then how do you meaningfully prepare a client? How do you do any of these things? I mean, there's a reason courts have held the more specific and more narrowly tailored it is, the better likelihood of enforcement, and I would argue a better likelihood of conviction or prosecution.
Right. And then finally, let's say Congress holds these two individuals in contempt. It's ultimately up for the DOJ to prosecute, correct?
Yeah, I agree with Congresswoman Cheney. The first time in 40 years is Mr. Bannon, and I mean, but that also includes Eric Holder, which was bipartisan, and Lois Lerner as well. I mean, and I think it's more important to recognize, I mean, the most important thing is if we continue to have people come in here and talk and go on TV and talk about compliance with the subpoena, the last way you're getting any of that information is by prosecuting them for contempt.
And then are you aware that DOJ has a long-standing position where they actually will not, they will allow executive officials to assert privilege and not hold that in contempt, and that goes back to Ann Gorsuch with the EPA. Would you like to expand on that?
No, but I mean, I think you can, I mean, I think the minute you start pressuring with rhetoric and other issues the DOJ to start dealing with these issues in these types of ways, you run the risk of, listen, there's not a ton of respect out there for Congress right now. It doesn't matter where you go anywhere in the country. The last thing in the world we need is that to be bleeding into the Department of Justice.
Thanks, Mr. Armstrong. I appreciate it. I yield back.
Thank you. I just want to, for the record, I looked up a quote from Kevin McCarthy. I quote, "Everybody thought Hillary Clinton was unbeatable, right? But we put together a Benghazi special committee, a select committee. What are her numbers today? Her numbers are dropping. Why? Because she's untrustable, but no one would have known any of that that had happened had we not fought." So I just want to, I get a little frustrated when I hear people lecture us about investigative committees being used to go after people inappropriately. And in the committee, the select committee that is before us today, we have a Democrat and a Republican, both who have equal subpoena power, both working together in what is a bipartisan way. The other thing is, I just have to say, I hear a lot of GOP arguments using Richard Nixon to defend claims of executive privilege. You should ask yourself what side of history you're on when you're using Nixon to justify your arguments. I don't think that's the side of history I would want to be on. Mr. Perlmutter.
Mr. Chairman.
Yeah, Mr.
The reason I was using that was because the law's unsettled, but Nixon, that case talks explicitly about executive privilege. So I'm not associating myself with what Nixon did by any stretch of the imagination, but the law is incredibly unsettled. So that's the case we have to look at.
Right. No, but I think what's even worse than that, quite frankly, is that I think some are associating themselves with what Trump did that day. And again, as I said to Mr. Armstrong, I mean, it is to me really just as a person who was there that day, who was one of the last people off the House floor, who saw the trauma that so many people went through that day, that that there just seems to be a lack of curiosity about getting to the truth and getting to the truth quickly. And I hope that we can overcome those obstacles. Mr. Perlmutter.
Mr. Armstrong, you practiced law a long time before you got elected here, right?
Yes.
Okay, so.
Well, I don't know what a long time is, a decade.
A decade?
Yeah.
Okay, well, I practiced about 25 years before I got here. So, civil side, right?
No,
You were a criminal lawyer?
I was.
No civil?
No, very little.
Well, I was civil, but I did get a guy jailed one time for having refused to answer depositions and interrogatories and document requests. 2 weeks he sat in jail because he, over and over again, refused to deal with any of the depositions, the document discoveries, or the interrogatories. So I know you only did criminal, but, what are the purposes of depositions and document requests and interrogatories?
Well, I would guess that if he went to jail for 2 weeks, a
No,
judge
my
sent him
question,
there, not a plaintiff.
my question to you were, what's the purpose of depositions, interrogatories, document requests?
They are to start recovery. I mean, I just use it as a discovery request.
Right,
It's the
to
same thing.
discover information that may be relevant to a basic case. Now,
Yeah.
in this instance, we have, in my opinion, a betrayal of the country by an attempt to overthrow an election. But that's what you know. We don't know much else other than a mob took over this campus, this Capitol campus, and broke into this building. And you got to begin somewhere. And you say, well, the questions keep adding questions. Well, maybe had they been the first people to respond to depositions, that would be one thing, but they've now had 800 witnesses to start developing the complexity and the breadth of what appears to be a really concerted effort to upset and throw away a lawful election. And you have 2 guys out of 800, and then you add Bannon and Mark Meadows, and that's it, 4 out of 800 who have refused depositions, interrogatories, document requests. And I appreciate you coming in here and trying to say, well, the record's unclear, but the purpose of discovery is very clear. And the purpose of this committee is very clear, to get to the bottom of this effort to overthrow the election and, in effect, overthrow this government. The number 2 and the number 3 people in line of succession as the executive, the vice president and the Speaker of the House, had their lives threatened. Says treason, the crime of betraying one's country, especially attempting to kill the sovereign or overthrow the government. And, criminal contempt, we're dealing with 18 U.S.C. 2381. Owing allegiance to the United States, levies war against them, or adheres to their enemies, giving them aid and comfort within the U.S. or elsewhere, is guilty of treason and shall suffer death, or shall not be imprisoned by less than 5 years. So, 800 witnesses. We now have 4 who've refused to provide any information. 1 is under criminal indictment for having refused to provide any information. We've got the Constitution of the United States has been victimized and assaulted. We have 5 deaths, dozens and dozens of injuries, countless people traumatized. And these 2 guys won't say boo. And it isn't a question of due process. They've had an opportunity to discuss this with their lawyers. They've had an opportunity to object and assert their rights, just as others have. So, I don't think there's any question as to the basics here about responding to reasonable discovery requests. And if they think that they are liable or culpable, then they can plead the Fifth Amendment. That's the rights that they have, that our Constitution gives them. But the Constitution also allows us to protect it. And so I appreciate you coming in here and reading us your brief. But I don't think there's any question on this one. I don't have any idea what these guys did or didn't do. I know we've got 7.5 hours of phone calls that are missing that I'd certainly like to ask them questions about. I don't know if you want to respond to any of that, otherwise I'll yield.
Well, first, everybody has due process. Hard
course they
cases
do.
make bad law. And if the idea is getting to the truth and getting an enforcement of the subpoena, a criminal contempt motion isn't the way to do it. And that would just be my point.
Everybody's entitled to due process, and they've had it. So the question of due process is, this committee has given them so much time, has given them an opportunity to be heard, and they've refused to be heard, and they've refused to appear. It's the right to appear and the right to be heard, which they've refused to do. Now they're going to end up having a criminal referral, and they'll have an opportunity in the court, just like Mr. Bannon did. But now, all of a sudden, there is an indictment, and he's going to have his day in court. You know, in my entire life, I never thought we'd be talking about these kinds of things. This is so basic. The legal premises is so basic, the constitutional premises, the fact that we had a mob overthrow this place. In a million years, I would have never thought that would happen. And we got to stop this. We got to stop it now. I mean, I appreciate Ms. Cheney coming in and the way she's described the Constitution demands for us to protect it. And, you know, I want to do that. I want to believe that if it were a mob of liberals who came and overtook this campus and broke into this building, that I would want to get to the bottom of it. And I believe I would. And that's why I really appreciate the way Ms. Cheney and Mr. Thompson and the rest of the committee have taken this on. This is not fun stuff. This is unbelievable stuff. And it's something that our founders feared. And they allow us to protect the Constitution, and we must. And with that, I yield back.
Ms. Fischbach.
Thank you, Mr. Chair. Just a couple of observations. We're talking a lot about how they refused. But what we're forgetting is there's a lot of correspondence that went back and forth. They were having discussions. The attorneys were going through all kinds of things. And my understanding, and you can confirm this, Mr. Armstrong, but Scavino offered interrogatories, and Thompson refused. So there's that issue that, so as we talk about that, maybe you just want to comment on that before I go on.
Yeah, there was numerous correspondence. Listen, I wasn't part of these negotiations. I can read the letters, that's what I can say. But it appears from reading through this that as these things continue to move forward, it was just a continued demand. There was no meaningful engagement as to the concerns that Mr. Scavino's lawyer had, and there would be months and time periods without any response, and then new deadlines set in, short periods of time, and continue to move forward. But none of those actual concerns were ever actually engaged with any meaningful way.
But there, Mr. Armstrong, there was kind of discussion, and I understand you read them, after the fact, but there was communication going on, and so I feel a little, the language here is pretty strong about how they just refused and kind of thumbed their nose, essentially.
Yeah, I think that's true, and you can even tell in some of the letters that you can tell that they've been talking offline as well once in a while and things. And I read it with some frustration on the side of Scavino's lawyer, but I also think we keep forgetting the middle part of all of this with due process, and it doesn't matter if it's a misdemeanor or a capital felony. Due process exists the same way. It doesn't matter if it's a civil interrogatory in a divorce case or a subpoena from a committee in Congress. Everybody has a right to have their case heard by a neutral arbitrator, and we continue to skip that part.
Thank you. I really want to associate myself with the, questions and comments of the ranking member and of Mr. Reschenthaler, and I wanted just kind of to follow up on something that Mr. Reschenthaler, he was kind of talking about and asking questions about the executive privilege. But I just want to ask, Mr. Armstrong, are you aware of any statute, rule, anything like that that would require a president to, President Trump in particular, to report directly to the Select Committee in order to invoke his executive privilege?
No, and at the risk of being admonished again, US v. Nixon is pretty clear on what this looks like and whether or not this is as settled of law as we like to pretend it is.
Okay, I just want to make that clear, that that is, so that, that when Mr. Scavino is invoking that's the, essentially, would you say it's an acceptable way to handle it in this case? Yeah. And Mr. Armstrong, just in finishing up, I just wanted to ask you if there's anything that you wanted to add or anything. Okay, thank you.
Thank you.
And Mr. Chair, I yield back.
Thank you very much. Mr. Raskin.
Mr. Armstrong, always a pleasure to see you. You were one of, I think, just 2 former public defenders in Congress, right? Is it you and Cicilline? Is that right?
Yes, I don't know if Morgan Griffith did public defense, but he did do some criminal defense.
Yeah, well, I want to thank you. I take you from our years together in the Judiciary Committee to be a serious lawyer, and I want to thank you for conceding the legitimacy of the January 6th Select Committee's legislative function and purpose. On that, you concur with the courts, and you're against, I'm afraid, the leadership of your party, which continues to say there's not a legitimate legislative function or purpose there. Will you just elaborate how you came to that conclusion?
Well, I mean, I read the Trump v. Thompson case, and I mean, listen, a very good district court judge told me one time, Mr. Raskin, even the courts aren't always right because they're smartest, they're right because they're last. And there's a ruling, and at least in this specific case, there is a court ruling when the Supreme Court failed to hear it that acknowledged the Select Committee's legitimate legislative purpose.
And I mean, the basic logic here is that if the Congress cannot investigate an attack on Congress, an attempt to overthrow an election, it's hard to think what we could investigate. But thank you for that, and I mean that sincerely. But I want to ask you this. Because of your experience as a public defender, and you just talked a moment ago about how, whether someone's going to civil court for a divorce proceeding or a criminal court for a murder trial or a parking ticket, whatever it might be, they're owed due process. Did you ever have a client, or can you imagine having a client who is subpoenaed to come testify about something, who thinks that their testimony could implicate them, who you would advise just not to show up? What would you advise someone who says, I'm nervous, someone I know is being prosecuted for something, and I'm afraid if I respond to this subpoena, it might implicate me? Would you tell them not to go?
Well, it depends where the subpoena is issued.
Well, a criminal court or civil court, as you say.
But this is important, because this is where we end up in this fight. We say, you have adversarial sides in this proceeding, and no independent arbitrator showed up. If an independent judge tells you to turn something over, I would advise them to turn it over.
Wait, but are you rejecting the long line of authority going back to the beginning of the Republic, that Congress has all the authority of a court to subpoena people's participation in a proceeding?
And the person being subpoenaed has the absolute right to have an independent arbitrator determine that. I believe that.
Okay, do you have any authority for that?
Sure, you can go to court to object to a subpoena. You can go to civil court to enforce a subpoena. We've been through this.
Well, okay. So here, though, there is one legal document that there's one legal command that's an issue, which is the subpoena from the House of Representatives. That is like a court ordering you to do something. If you don't like the ruling of the court once you get there, you can appeal it. And as you were just saying a moment ago, you can go as far as you can go appealing it, but you can't blow off the court. I mean, did you ever have a client who you told just don't show up if you think you've got a Fifth Amendment privilege or any other kind of privilege? No, I assume you're being an excellent lawyer. You would say you go to court, and when they ask you questions X, Y, and Z, you assert the Fifth Amendment, or the marital privilege, or whatever privilege it is, right? I'm sure you did that countless times in your career.
Yeah, but I don't agree with the correlation. I mean, I've had plenty of document requests and subpoenas in which we have gone to a court and fought about them, and I've had plenty where I've forced prosecutors to enforce them.
Yes, you've gone to court, but you haven't just refused to show up. That's what these guys have done. They've refused to show up.
Well, if you think, I don't think Mr. Scavino just refused to show up.
Did he go to court?
Mr. Scavino engaged with this committee for 9 months straight and never got real answers.
All right,
And
yeah, okay.
the committee's enforcement action is a civil enforcement action.
All right, let me ask you this. To whom does the executive privilege belong? Who gets to assert it?
Well, President Trump has asserted it with Mr. Scavino.
But as a matter of law, who gets to assert the executive privilege?
The executive.
Okay, so it's not a private party. Scavino can't assert the executive privilege, right?
I don't think he's arguing that he.
Navarro can't assert the executive privilege. The Supreme Court held in United States versus Reynolds in 1953, and multiple times since then, the executive privilege belongs to the government and must be asserted by it. It can neither be claimed nor waived by a private party. Do you have any precedent that contradicts this?
Well, I have U.S. v. Nixon, which says that a former president has abilities to have privilege.
Okay, let's say that were the case, okay? And it's dubious given that the D.C. Circuit just held the privilege, like all other Article II powers, resides with the sitting president. But even if that were the case, how does that help Mr. Navarro? We haven't heard from Donald Trump. Navarro hasn't given us anything saying Donald Trump is trying to invoke executive privilege for him. So how does that help Navarro?
Well, I mean, I would have, listen, if I was Mr. Navarro's lawyer, I probably would advise him to do some things a little differently.
To come in and testify, right?
Well, we're in the middle of one contempt rule, one contempt order. So as we continue to move this, it seems like the rule doesn't make any distinction between Navarro
Okay, well, let me ask you then about the content of it. Do you concede that the executive privilege applies only to the valid work of the executive branch? Can a president, assert executive privilege for political campaigning that he's involved in or one of his subordinates is involved in on their own time?
I don't even know if I know the answer to that. I haven't looked at it.
But the answer is no. I mean, the Hatch Act makes it a crime for someone to engage in political campaign work on their job. So essentially, you'd have to be saying, well, I was violating the law and doing as part of my job campaign work. So the answer is no. Much less can you assert the executive privilege for criminal activity. Would you concede that point?
Well, that's the line that I think is important and also where the distinction lies in U.S. v. Nixon.
Yeah, well, I think that's where we are because the investigation that we're doing under House Resolution 503 is into a massive violent assault on the Congress, the first successful effort in the history of the United States to interrupt the counting of electoral college votes in order to overthrow an election and to falsely continue a presidency, to seize the presidency for the first time in American history. That's criminal activity. So the idea that executive privilege could cover anything related to it is just fantastical. It's preposterous. But I appreciate you're in a tough position. I think you've done a pretty good job given what you're defending there today. I really do. And I thank you for conceding the legitimacy of the legislative purpose and function.
If I may,
Please.
I would just say the best place to investigate criminal activity and probably the only appropriate place is the Department of Justice and not the House.
Yeah, well, we're not prosecuting anyone. Our charge is to try to determine what happened, why it happened, and how to make sure it never happens again. Nothing could be more serious than the protection and the preservation of democratic institutions. And that is why this is a legitimate legislative purpose and why the overwhelming number of people have cooperated enthusiastically with the investigation. Thank you for being here today. I yield back.
Thank you. Ms. Scanlon.
Thank you, Mr. Armstrong. Feels like we have had parts of this colloquy before when you were back in December. And you stated then as now that you think the subpoena is premature, but one of these subpoenas was issued last October and the other was issued in February, right?
Yes.
Okay. Now,
Well, yeah, there's some service issues at the front end, but I'm not particularly, I'm not his lawyer, so, but yeah.
okay, I mean, I think there's some urgency, particularly when leadership of your party has indicated they're going to upend the J6 committee if they should take control of the House in the fall. So we've talked a little bit about what the options are when you receive a subpoena. I mean, the first and obvious one is you show up as instructed. The second one is you show up, and if something is asked of you that is objectionable, then you object and you narrow the issues at that point. Isn't there also the option that you can file a motion to quash or narrow the subpoena? I think you just alluded to that.
Sure, or you can engage with the committee and force them to file a motion to
Okay.
enforce it.
Okay, but neither Mr. Navarro nor Mr. Scavino have filed a motion to quash or narrow the subpoena, have they? Okay, they're just willing to force the committee to enforce the subpoena and then whine about it being too early.
Well, they're not forcing them to enforce it, they're forcing them to prosecute it.
Okay, all right, I have nothing further.
A contempt motion's not an enforcement provision. This will, I mean, this is a penalty, it's not an enforcement provision, so.
But a penalty designed to enforce compliance, correct?
I don't think I agree with that.
All right, I yield back.
Mr. Morelli.
Yeah, I don't have much to add. I just wanted to make what I think is a clarification. It's been suggested that a former president can assert privilege, but I believe it transfers to the office. I don't think it's the individual. I don't think the human being makes that. I think it's the current president who would make a determination. And I think what happens in practice anyway is past presidents designate someone who represents their interests in conversation between the National Archives and the current office holder, and the current president makes those decisions. That's the way it's done.
Well, that's, in the narrow ruling for the archives, yes, that's what Trump T. Thompson.
No, but I think in any case, I think even if it's outside I think the National Archives is where those papers are, that's where the material is. But I think even when it comes to claims of executive privilege, that the current office, it goes to the office, not to the individual. The individual doesn't, as I understand it, doesn't make that determination. It's the office of the president, whoever happens to be in the office. Now, that'll be litigated, I'm sure, but I don't think President Trump has the right to exert executive privilege. I think the determination will be by the president.
I think that at the very least, that question's unsettled.
I don't know that it's unsettled. You may challenge it with the existing Supreme Court, but I think that's how it's been determined in the past. The other thing I would just note, I mean, Nixon lost. I mean, it's a qualified privilege. Privilege is not absolute, it's qualified, and I think the court ruled unanimously that Nixon, because he was engaged in wrongdoing, the court unanimously ruled against him. And I would argue that on January 6th and the weeks leading up to it and the weeks leading after it were about overturning illegally an election that had been decided for which there was no evidence of fraud, as I said with the earlier testimony. So I would actually argue what they were engaged in was wrongdoing. It violated the Constitution. And so if you're engaged in sedition, you don't have the ability to argue, well, it's executive privilege. If you're engaged in wrongdoing, to overturn the Constitution or overturn the law of the land, the members of the administration, even if they're giving advice, as you've described, if you're engaged in an unlawful activity, that's not protected. You would agree with that. You might not argue that they were engaged in wrongdoing, but I assume you would argue you cannot extend privilege for wrongdoing.
And I think the first Nixon case and not the second case said for the very specific things on that is in criminal cases. This is not a criminal case.
No, but I don't know that it's not a criminal case.
Well,
If
it
it's-
is a
if it
criminal
ends in
case,
sedition-
then we have a legislative function problem in a really quick hurry.
Well, it could end in a criminal case. This is not a criminal case. It's the oversight of Congress, which has the right to do oversight, has the right to subpoena witnesses who they believe can give information that's pertinent. But it doesn't mean that in my view, they're protecting what is wrongdoing, and wrongdoing is that's not protected. But it'll be decided, perhaps. But neither Mr. Navarro or Mr. Scavino chose to appear. I mean, I also assume that Mr. Scavino could appear and answer. I mean, clearly has some information that even he would argue would be pertinent to the inquiry, which would be outside the scope of you're arguing that it's outside the scope of the inquiry. Some of the questions, some of the things that were asked for outside the scope. Is that not what you argued?
Yeah, I think there's a subpoena that has 15 things. There's document requests, there's testimonial requests. Throughout the course of the correspondence, that expanded to 33, plus the catch-all. They could never come to an agreement on either the document request or narrowly tailoring of what the testimony would actually be. And his lawyer simply said, we cannot adequately prepare our client for coming in here under these circumstances.
So, but there wouldn't be a point in arguing about the specifics if you were going to assert that none of it was, that you weren't going to share any of it because of executive privilege. If the executive privilege ran to the whole thing, why would you argue about all the specifics that are underneath that?
I mean, they make the executive privilege argument and that Trump has asserted it, but they also, there's a duplicative argument from the archives, there's a narrowly tailored argument, there's a lot of things in from, listen, I have.
But why would he go back and forth and have that argument about particulars if he believes it's covered under executive privilege?
Well, I'm not his lawyer, but I'm not sure they know, I'm not sure until you get to that point, they know what is and isn't covered.
And yet he didn't decide to comply with part of the subpoena. He didn't agree to say, I'll come and testify about the following. We can argue about the other ones. I'll come down and testify and give depositions about the following things that I think are truly part of that are covered under the
I am
scope of the
almost
inquiry.
certain, and I don't know this for sure, that he was never given that option.
Yeah, I mean, I don't know that that's the case. Would you like to comment on that?
Yeah, but I'll just make the point that for every witness who is acting in contempt of the committee has said, come in and testify on those things that we agree are not covered by executive privilege, for example, or Fifth Amendment privilege, and then you assert the privilege, which is, as you know, Mr. Armstrong, the way defendants do it. You go to court, and if you think you've got a privilege, you assert it then. You don't blow off the proceeding.
Well, and I'd also, how does this get adjudicated in your opinion? How do we ultimately decide whether Mr. Navarro and Mr. Scavino should be compelled to testify?
Well, you have Trump v. Thompson, you have Trump v. Mazars. If your answer is to actually compel the document production and the testimony, the civil enforcement action is the way to go. I don't think the criminal contempt motion is going to get the committee what they want, but that's just my opinion.
So your argument is we just sit around and wait. Congress doesn't do anything until the court cases are decided at the Supreme Court?
I think everybody who has a subpoena issued to them has the right to have a neutral arbitrator determine it when they have a legitimate legal dispute.
Well, it seems to me that ends up in and I think this is by design, just a stalling tactic to make sure we wait years and years if necessary to get to any information. I mean, I think that's the whole point of this.
Mr. Morrell, if you want to work with me on a way to make the federal court system work faster all the way around, I am absolutely.
I'm sure I would agree with you on it. I'll yield back, Mr. Chairman.
Thank you very much. Mr. DeSagne has no questions. Ms. Ross?
Mr. Chairman, I have no questions, but I know that my colleague here, Mr. Neguse, does.
I'm going to yield now to Mr. Neguse.
Thank you, Mr. Chairman. Well, it's good to see you again, Mr. Armstrong, whom I consider a dear friend. I do think you have an unenviable task today of defending a case that I think is very difficult to defend under the facts that we're considering today. So just taking a step back, because Ms. Scanlon noted this or articulated it, and I thought it was well said. Mr. Clark, the last time you were here in front of the Rules Committee, I believe, was during the contempt resolution that was introduced and that the Rules Committee was considering regarding Mr. Clark. Yes. You recall that. And I seem to remember a lot of my colleagues, my friends from the other side of the aisle, claiming that the sky was falling and that the House should not proceed with that contempt resolution, so on and so forth. Has the House considered a contempt resolution against Mr. Clark?
No.
Why not?
Because he complied, or he testified.
Because he testified. No, that's right. No, you're precisely right, because he testified. Because he responded to this committee initiating the resolution to the floor by coming in, testifying, and my understanding, I'm not on the select committee, is that he pled the Fifth Amendment, or at least that's what some reporting indicates. So he complied and came in and did what you are supposed to do, which is show up and answer the questions that are posed to you pursuant to a duly issued subpoena, and if you believe you have a privilege to invoke it there and then. So to the extent that the argument is that there's no deterrent impact of a contempt citation proceeding, I think that that's a bit much, and I think that case, perhaps provides some evidence to the contrary. I hate to belabor this, because I think Mr. Raskin has articulated this, Mr. Perlmutter has articulated it, Ms. Scanlon has articulated it, but I must. When someone receives a duly issued congressional subpoena, right, they have choices. They can comply with the subpoena, appear in front of the Congress or the committee that has issued the subpoena and answer the questions. Or they can move to quash that subpoena, correct? They can go into court, and many witnesses, my understanding, have received subpoenas or are the subject of subpoenas that have been issued, for example, to wireless carriers for phone records, and they have gone into federal court in an attempt to quash those subpoenas. Those are legitimate options that witnesses can pursue. My understanding of your argument is that you believe there is a third option, which is ignore the subpoena completely, don't move to quash the subpoena in a court of law, simply stand back and say, if you'd like me to testify, you need to initiate a civil enforcement of that subpoena. Is that the argument you're making?
Well, yeah, except no, not entirely. I mean, they didn't ignore the subpoena completely.
Sure.
Scavino engaged in good faith arguments as to what the subpoena was.
I take you at
what
your
their
word.
issues were.
Let's say you negotiate, you go, in good faith, you exchange letters and so on and so forth. Ultimately, fundamentally, you're still making a decision at some point to say, you know what, we're not coming in, and we're not initiating a legal proceeding. Well, what are you doing? Well, we're going to basically wait and compel the Congress to initiate an enforcement mechanism to force me, the witness, to come testify. That's your position.
Well, they made very good faith, colorable arguments as to what they had problems with and never had any meaningful response. So
Then why not show up and make those arguments? Why not appear and invoke the Fifth Amendment, invoke the executive privilege, even though, as we've discussed ad nauseum during this particular hearing and in hearings in the past, as Mr. Morelli eloquently articulated, I don't think that ultimately that privilege is a privilege that the witness can assert during the pendency of a deposition like this, but fine, show up, assert it, and say, I'm not answering that question. You listed a litany of other objections that these document requests or the testimonial requests are duplicative. Say it's duplicative. I decline to answer this question. I believe it's duplicative. I'm going to force the committee to initiate a lawsuit to compel me to say it. Why not do that?
Well, I'm not there giving advice to Mr. Scavino. I'm not his lawyer. I'm not in those conversations, so I don't have a reason for that. But I can honestly tell you that I know just from reading the letters that they don't think they had any meaningful engagement with the committee.
Well, I'd say this, and I said this at the hearing in December, because I take you at your word, as Mr. Raskin said, given your background and I think your fidelity to the law and as a serious lawyer, kind of wrestling with these arguments. But my colleagues on the other side of the aisle are creating a standard that is untenable and will prove to be unsustainable over the long haul. And to the extent, I'm happy to yield to my colleague for a particular question, to Mr. Reschenthaler, because the day may come when my colleagues have the gavel. I hope not too soon. But when that day comes, my construction of your argument, as I understand it today, and in the hearing that we had in December, and in the hearing that we had in November on Mr. Bannett's contempt citation, is that any witness who believes that their testimony would in some way invoke executive privilege need not show up in response to a congressional subpoena and need not move to quash that subpoena. Any witness in the Biden administration, any individual employed by the executive branch, in the State Department, in the Defense Department, in any other agency that my colleagues on the other side of the aisle are interested in potentially questioning need not show up under the standard that apparently you all have adopted over the course of this last 6 months. If I am wrong on that front, I yield to my colleague to correct me.
So thanks, Mr. Neguse. I appreciate it. What I actually wanted to jump in on was the question of why Mr. Scavino just won't come in. Look, I'm not Mr. Scavino's attorney, obviously, but if I were advising him, I'd say there's a few concerns. Okay, number one is just the scope of the questions kept changing, which is a problem because you cannot prepare a witness when you cannot get nailed down what exactly is going to be asked of that witness. So that's one. Number two, there's a lot of due process concerns here. You don't want to waive those arguments by coming in. And finally, there's an argument to be made. I don't know how compelling it is, but the committee's own rules were not followed. And if you look at case law, when the committee, even the quorum is being busted, it's questionable whether anything that comes out of that can withstand in court. So just for those reasons, so there are legal reasons why Mr. Scavino might not come. Thank you for yielding to me. I yield back.
I would just simply say, and I appreciate the gentleman and the argument that he's making. Apparently, all of these witnesses are reading from the same song sheet because Mr. Navarro, Mr. Bannon have all reached the same conclusion that they couldn't be properly prepped, and so therefore they shouldn't appear before the Select Committee to answer these important questions about the worst attack on our nation's capital since the War of 1812. In any event, I digress.
Would the gentleman yield?
I
just
yield
for a
to
quick
my
question
colleague
to the
from
witness,
Colorado.
Just because I keep sort of getting these mixed up. So you keep talking about Scavino, and then you say they. So do you make a distinction between what Mr. Scavino's done in response to the subpoenas versus what Mr. Navarro has done, which is nothing, in response to the subpoenas? So are you making a distinction between these two? Because you talk about Scavino and you say they are entitled.
I mean, the short answer, no, I really don't mean to, I don't mean this to be as brief and glib as it is. I don't have to. There's only one rule. We're only having one vote. And, I mean, there's just, if they're both being brought under the same thing with two very distinct responses to the committee, I think you can, anybody with two eyes and ears can tell that these two people have had two very different and distinct responses to the Select Committee. But as it doesn't matter because they're being brought together on the same rule and the same vote.
And personally, I don't think we have to make a distinction, but I was just curious if you were making a distinction, that Mr. Scavino at least has had some communications versus Mr. Navarro, who's had none.
I think they have very distinct ways in which they
Okay,
respond.
thank you. Thank you, Mr. Nagus.
I yield back the balance of my time.
Any further questions? Hearing none, let me just close by saying that, let us not forget what happened on January 6th. This vicious, brutal attack on this building, on the people who work here, on our democracy, and the fact that we have an obligation to get this right and get to the truth. And I would like to think we could have done this, as I said earlier, under unanimous consent, that there would be unanimity here, that it was vital that we get to the truth. Apparently, that's not the case, and so we're going to have to proceed with what we have here, and I wish this were a strong bipartisan vote. I gather it will not be. That's unfortunate for this institution and for the country. But I thank you for being here. You're free to go. And that, any other witnesses? Seeing none, then this closes the hearing on this resolution. At this time, the chair will entertain a motion from the distinguished gentleman from Maryland, Mr. Raskin.
Mr. Chairman, I move the committee provide for consideration of the resolution accompanying House Report 117-284 under a closed rule. The rule provides that if H. Report 117-284 is called up by direction of the Select Committee to investigate the January 6th attack on the United States Capitol, all points of order against the report shall be waived and shall be considered as read. The rule provides 1 hour of debate equally divided among and controlled by Representative Thompson of Mississippi, Representative Cheney of Wyoming, and an opponent or their respective designees. The rule waives all points of order against consideration of the resolution accompanying the report. The rule provides that the resolution accompanying the report shall be considered as read. Yield back.
You've heard the motion from the gentleman from Maryland. Is there any amendment or discussion? Mr. Cole.
Thank you very much, Mr. Chairman. Mercifully, this isn't on the substance of the rule, but it does cover something. I asked the committee add language to the rule that would continue the tolling of days for the motion to instruct conferees. Mr. Chairman, last week's motion to request a conference with the Senate on the Competes Act, which was adopted by unanimous consent, I might add, highlights another of the lockdown procedures which which were implemented 685 days ago, tolling the days for motions to instruct conferees. While not as old as resolutions of inquiry, motions to instruct conferees have existed since 1931 and are an opportunity for the House to continue to make its will known to the managers during conference. As it is possible that the Senate could agree to go to conference later this week, it's critical that this important tool be restored so that all members, Democrats and Republicans, are able to offer appropriate privileged motions at the proper time. So I urge adoption of the motion and yield back.
Heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. Neither chair, the noes have it.
On that, I'd request a recorded vote.
Recorded vote has been requested. Clerk will call the roll.
Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter?
No.
Mr. Perlmutter, no. Mr. Raskin?
No.
Mr. Raskin, no. Ms. Scanlon?
No.
Ms. Scanlon, no. Mr. Morelli?
No.
Mr. Morelli, no. Mr. DeSaulnier? No. Mr. DeSaulnier, no. Ms. Ross? Ms. Ross, no. Mr. Neguse? Mr. Neguse, no. Mr. Cole?
Aye.
Mr. Cole, aye. Mr. Burgess? Mr. Reschenthaler? Mr. Reschenthaler, aye. Mrs. Fishbach? Mrs. Fishbach, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
3 yeas, 9 nays.
Members not agreed to. Further amendments? Hearing none, then the vote will now be on the motion from the gentleman from Maryland, Mr. Raskin. All those in favor say aye.
Aye.
All those opposed say no.
No.
In the opinion of the chair, the ayes have it.
That I'd request a recorded vote,
Recorded vote
Mr.
has been
Chair.
requested. Clerk will call the roll.
Mrs. Torres? Mrs. Torres, aye. Mr. Perlmutter?
Aye.
Mr. Perlmutter, aye. Mr. Raskin?
Aye.
Mr. Raskin, aye. Ms. Scanlon?
Aye.
Ms. Scanlon, aye. Mr. Morelli?
Aye.
Mr. Morelli, aye. Mr. DeSaulnier?
Aye.
Mr. DeSaulnier, aye. Ms. Ross? Aye. Ms. Ross, aye. Mr. Neguse? Mr. Neguse, aye. Mr. Cole?
No.
Mr. Cole, no. Mr. Burgess?
No.
Mr. Burgess, no. Mr. Reschenthaler? Mr. Reschenthaler, no. Mrs. Fishbach? Mrs. Fishbach, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk report the total.
9 yeas, 4 nays.
Motion is agreed to, and Mr. Raskin will carry it for our side.
And Mr. Reschenthaler will carry it for the Republicans.
So no other business today. Without objection, the committee is adjourned.